All rise. Court of Appeals Division 1 is now in session.
Be seated. Good morning. Now's the time set for oral argument in cause number 1 CACV 150642, Jacob Richardson versus ALL Services Unlimited, Inc. For your information, these proceedings are being both audio and video recorded, so barring any unforeseen technical problems, you can critique yourself on YouTube in a few weeks. Counsel, each side will be entitled to 20 minutes, and we would ask that you respect that time period. The timer located on the podium will let you know how much time you have left. And appellant, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know so we can avoid taking up all your time. However, ultimately, reserving rebuttal time will be up to you. We've reviewed the briefs. We've conferenced the case this morning, so we are well aware of the facts and issues attendant to this argument. You might want to keep that in mind in regard to how you organize your argument and present this morning. Counsel, when you come to the podium, I would ask that you state your name and who you represent. And with that, counsel for the appellant, you can begin.
Good morning, Your Honor. May it please the Court, my name is David Abney. I'm here today with Peter Donovan, representing the plaintiff appellant. Every day I read an old newspaper 100 years back and 75 years back, being an historian, the Arizona Republican in 1916 and the Arizona Republic for 1941.
You don't just remember those days, Mr. Abney?
No, sir.
Okay.
And this year in 1916 at the Arizona State Fair, the premier event was polo played with motor vehicles, which is an exciting event. They would crash the vehicles into the ball, a big ball, and then try to score. The crowd apparently loved it. I feel that a little bit that way today. It's a difficult subject in some ways because you're trying to say, well, in a situation where you can always do more, you can always investigate more and keep probing and probing. We had a gentleman who was injured at a work site, and what he saw was no sign of a general contractor.
Was there, whether he saw it or not, was there actually a sign?
The contractor says, yes, there was a sign, and Mr. Richardson says, no, I didn't see any sign, there was no sign. So you have a conflict of fact there that only the jury can resolve.
How long was he on that job site?
He was there for 2 days.
So he hired, worked 2 days, and was injured on the second day?
He started at the job site January 23rd, and he was injured the 25th. If that's 2 or 3 days, however the math works out.
For purposes of Rule 15, not the discovery rule, but Rule 15, does it matter that there was a sign and he didn't see it?
I don't think so. No.
I mean, reasonable investigation.
Right.
It deals with the discovery rule.
Well, reasonable investigation, although Rule 15 is, and there's a case I just discovered last night, Arana. It's not published, ARANA. It's very recent, September 29, 2016, really focused back on the situation you have here. You have mistakes, and it says, well, mistakes are just, that's what Rule 15 is about. And,
right.
And you can have a mistake that's just an obvious mistake, or you can have one that's serendipitous.
I mean, Krupski, which is the U.S. Supreme Court's case, if I remember right, has the woman on a cruise line, and I think her ticket says if you have a notice of claim, you got to sue the cruise line. And she didn't see that, so she basically files the claim with the marketing agent. And ultimately, the statute of limitations runs. She makes an amendment, relates, and the Supreme Court said it relates back. So that's a mistake.
Well, it's a mistake of identity.
Yeah, I understand. It's a mistake of who you're supposed to be suing. Not a legal mistake, a factual mistake.
Right. And there again, I would submit it's really it's not something for the court to be dealing with when you're dealing with a mistake of fact. It really should be for the trier of fact.
So do we even consider the reasonableness of the mistake. I mean, take for example, if they actually did have a huge sign, so we are the general contractor that most people could see, and serendipitously or otherwise, your client didn't see the sign. Does that mean that he made a mistake under Rule 15?
I don't know if that really fits in with Rule 15 or not, but I would say he made a mistake. Certainly, well, actually, I don't know about that. The mistake is really what is the identity of the person who needs to be sued.
So
if he doesn't have a clue, I don't know what you call it. If it's a mistake, not mistake, non-perception.
So are you behooved to not pay attention if you go on a job site?
Well, you remember Forrest Gump, who always made the mistake, but it always turned out well?
Yeah.
You could have that sort of person that's just sort of oblivious to the world, and if he honestly doesn't see the sign, I don't know how you can hold him liable for that.
And that's not a jury question, is it? I mean, the judge has to decide as a matter of law whether it relates back. If he made a mistake, if he says, I didn't see the sign, I didn't know this, when I was alerted to it, I did what I was supposed to do. I made a motion to amend. The court makes a legal determination whether it relates back, unless there's a true factual dispute about was a mistake made. I mean, where someone says, I told him, no, he didn't. In other words,
Sure.
Look at the hypothetical of
Right.
He gets hurt and he goes to the owner, and the owner says, I'm not in charge as a general contractor.
Right.
And the plaintiff says, you didn't tell me that. I didn't know that. Well, that's a factual dispute, I guess.
Right. Well, I think no matter how you slice this, whether you're talking about the discovery rule or Rule 15, there is a mistake that's happened here. Rule 15 is more the mistake of the identity of who you're going to sue, and the discovery rule was who was in charge of this site, who's actually liable.
It does seem to me the discovery rule, if there's a factual dispute, it goes to the jury.
Yes, it
Genuine
does.
dispute of material fact. If a person just, the evidence here is there's a sign, I didn't see it, he made a mistake.
Correct.
Mr. Abney, we've differentiated in the past cases where someone either knew the identity and just didn't bother to amend timely,
Right.
or where they sued what they knew were spurious parties and
Correct.
and didn't bother to investigate who the actual person was, and we've said that's not a mistake. How do you differentiate your case from this case?
Well, it's the second part you're dealing with, the spurious party sort of business, I think, is the more deadly for this particular case. And I think the situation is he knew, based upon his experience in the industry and what he had seen, he saw the landowner actually doing things at the site, trying to remove snow and ice. Saw no hint of any general contractor, no sign, and none of the characteristics of general contractor activity, which are safety meetings and other sort of organizational meetings. He saw nothing. So he knew, just as surely as he knew the sun rises, that this was just an owner-operator, an owner-landowner sort of affair. It wasn't an affair involving a general contractor. Now, when you know something like that, should you go on then and investigate, even though it's counter to what you, in quote marks, know? And I submit that you don't. You go with what you have seen. Now, it turns out, of course, that the general contractor, at least their lawyers, knew when the complaint arrived, and within 120 days after service of the complaint, they knew the mistake had been made. And they sort of sat back. I can't really blame them, although some people would have come forward, but they sat back and waited, and then when it's too late, they spring the motion. They do the motion to dismiss. Okay, that's fine, but still, I think we're within Rule 15C, fairly enough.
That certainly could not then have created a surprise.
Well, it will surprise the plaintiff.
Well, but to a defendant.
So the
No, it
defendant-
didn't surprise the general contractor at all.
They knew the case was out there. They
Right.
knew they were the proper party.
Correct.
They just also knew they hadn't been served.
Right. And, some people would have said, well, hold on, Clem, you really need to be suing us and have come forward. And some people don't. That's just the way litigation plays out sometimes. I could go on, but my interest is a conversation, and if there's no questions right now, I can reserve my time.
I can't help me on this. So he sues the general contractor. Does the general contractor tell him in the disclosure statement, suing the wrong guy, you should be suing the general contractor?
It was in the response to the motion to dismiss, and it's in the.
But I mean, go ahead.
Are you asking what the general contractor's lawyers knew?
No, what the
Property
property owner said. You have a case.
Mm-hmm.
But the case was filed right before the statute of limitations.
Yeah, shortly before.
So
a couple days.
Don't worry about it.
Yeah, no time for that. Yeah, most defendants would say, hold on, I'm not in this boat by myself. Go sue the other people.
But even if they did in this case, because he sued right before the statute of limitations ran, if by the time they got the answer or the disclosure statement, the statute would have run, it was disclosed, he acted within the time. So,
yes, Your Honor.
Okay.
Okay, I will reserve my time.
Good morning, Your Honors. I'm Michael Herzog. I represent the appellee in this matter. There are a couple of things that I'd like to clear up immediately that were just said. One, there was some allegation that the lawyers for the appellee had some knowledge that the wrong party had been sued. I have absolutely no idea where that comes from. I have absolutely no idea where that comes from. I've been the lawyer for the appellee the entire case, and the lawsuit was not filed until the appellee was not joined in this case until 2 years and 3 months after the event occurred. We raised the statute of limitations events. I have no idea what they're saying we should have known about. We certainly didn't know before 2 years had elapsed that there was a lawsuit against Bellamont. So that, I have no idea where that allegation comes from. But also,
did you know about the accident or the mishap?
No, there's no evidence whatsoever that we knew about that we were going to be a defendant. Certainly my client knew there had been an accident, but I don't think my client had any knowledge that there was a lawsuit filed against Mr. Bellamont. Against Bellamont Truck.
My point to add to what Judge Howe said was it may not speak well of your client if for 2 years there had been an accident, a personal injury or an injury that occurred there, and that he didn't become aware of it for 2 years on a job where he was the general contractor.
Well, I think it's important to also note, and the other point I wanted to make, it's not that there was a mistake that the owner was sued instead of the general contractor. The owner was the guy who was clearing snow off of the pad, and it's not like they amended their complaint and dismissed as to the owner. They did not dismiss us to the owner. Mr. Oldacre and Bellamont Truck Repair are still defendants in this case. That portion of the case has simply been stayed while this decision is made with the Court of Appeals on the issue of statute of limitations. It's not like they're saying, oh, yeah, we made a mistake in suing Bellamont. Bellamont is a target defendant in this case. So I don't want to make – we're the only party on the appeal because of the way it worked out. But I think it's important to recognize it's not a mistake like, oh, we sued the wrong party. We should have sued all services.
Right.
Yes, sir.
But the issue before the trial court was whether a mistake had been made, right?
Right, whether a mistake had been made.
For purposes of Rule 15,
right.
That was the issue. Whether a mistake for purposes of Rule 15 had been made, right?
A mistaken identity had been made,
yes,
correct.
Understand.
Right.
Understand.
Yes, sir. Yes, sir.
So that's the issue we need to be focusing on.
Right, and what I'm trying to say, probably inartfully here, is that it's not a mistaken identity. It wasn't like Bellamont was sued as just simply the wrong name or the wrong party that, they thought this party had certain responsibilities, but it wasn't that party, it was my client. They understood who Bellamont was. They understood that Larry Oldacre and Bellamont owned this piece of property, and that Larry Oldacre, on behalf of Bellamont, was there every day, and he was actively involved in the maintenance of the property. It's not that they had made a mistaken identity, it's that they just failed to add an additional party. My client is an additional party, not a mistaken identity party.
But counsel, you've been around for a long time. You know what an owner-builder is. You know the notion of an owner-builder.
Well, it can be a
How-
number of
How
different
can we
things.
differentiate Mr. Oldacre? I don't know what the term would be when you're talking about commercial steel construction, but he owns the property, they're there working, he's cleaning the job site, he's jockeying things around, doing whatever to make it possible for them to come in and do their job. The appellant is only there for 2 days before
Right.
he's injured. What was there that should have made it so there wasn't a mistake that Oldacre was managing this construction project himself?
Well, it's not just the 2 days that he's there, it's the 3 months afterwards. You know, he's got an obligation after he gets hurt to try to decide who it is that he should have sued. And
Counsel, can I interrupt you for a minute?
Sure, of course, yeah.
I think what you're trying to get into is, did he make a reasonable investigation
Yes,
for purposes of the discovery rule?
yes.
Is there a case that says if you make a mistake but it's not a reasonable mistake for purposes of Rule 15, it's not a mistake?
Not that I'm aware of, but what I was, and I understand what you're saying, but that's why I started the way I did. I think it's important to understand that it's not that, oh, my client actually occupied the space Bellamont was thought to occupy. It's not that plaintiff thought that my client's true name was Bellamont, or that my client occupied Bellamont's, and Mr. Oldacre. Mr. Oldacre actually is also a personal defendant in the case. They knew exactly what they were doing. They were suing Larry Oldacre for Larry Oldacre's actions, his own actions in the way he cleaned off the slab from snow and ice. And that was what they were doing. They didn't make a mistake that my client was Larry Oldacre. They just did not
Understand that.
know the existence of my client. And that's the distinction we tried to draw in our brief. And I think that is an important distinction when you look at the case law. I think that difference, it has to be a mistaken identity. It was not a mistaken identity in this case. There was nothing, it was not a situation where the classic, Grand Canyon Ritchie case where, oh, who does business as the trail ride? That wasn't the situation. That was not the situation. It was not a mistaken identity. And I don't, pardon me just for a moment, Your Honor.
So your view is that all services, as far as the plaintiff is concerned, they just don't know. They just don't know all services is out there. It's not that they think that someone else is all services.
Yeah, they don't think that they don't think that Oldacre is us. They don't. It's not a situation where that if they had known who we were, they would have named us instead of Oldacre. No. And I think that's what's required under Rule 15C to have a relation back. It has to be that there's a mistake made as to, once again I keep saying it, but as to the identity of the party.
So you're saying that if Rule 15 is limited to, if there were two corporations, let's say Joe Smith, Inc., and the parent company, Alice Smith, Inc., and all I know about is Joe Smith, Inc., then I find out after statute of limitations that really everything was being done by Alice Smith, Inc. That's what it's limited to.
Basically correct.
So, but as opposed to if I think that Joe Smith is the only corporation, and in fact there's a totally different corporation out there involved in some kind of operation.
In addition to Joe Smith,
let's do a hospital. Let's do a hospital thing. I think Dr. Howe has operated on me. I'm wrong. Dr. Howe wasn't the doctor. It was Dr. Jones. That's not a mistaken identity, right? Because I just didn't know about Dr. Jones. So I can't, when I start taking discovery or I file my complaint, and Dr. Howe comes back and says, I didn't operate on you. Dr. Jones did the surgery. I can't add him.
I would say that that's not our case, and if you don't mind, I'll use the same analogy you're using to sort of explain the difference. I would say if Dr. Dr. Smith, I forget the names.
Dr. Howe and Dr. Jones. Let's keep it easy. That's Dr. Howe, that's Dr.
Sure.
Jones.
Plaintiff sues Dr. Howe, who he thinks operated on him, and Dr. Howe actually did operate on him. In this case, plaintiff has sued, from your hypothetical, plaintiff has sued the doctor who did the work on him. He hasn't sued in a timely fashion the assistant surgeon.
Okay. So what happens if both of them operated on me?
And
I sue Dr. Howe, but I don't know about Dr. Jones.
That's right.
They're saying can't relate back.
Can't relate back. It's not a relation.
I didn't know about him, Dr. Jones.
Right. It's not a relation back situation. It's a question of a discovery situation. That becomes the discovery rule. It doesn't relate back in that situation because there's not been a mistake about whether or not Dr. Howe should be sued. Dr. Howe in that situation would be a proper party, but plaintiff would not know about Dr. Jones also sued him. So it's not, I'm sorry, go ahead.
Go ahead.
It's not a relation back situation. It's a discovery rule situation as to Dr. Jones because plaintiff says, wait, I did not know that Dr. Jones was also in the operating room at the time that Dr. Howe operated on me.
And what's your best case that says in that kind of situation, relation back, where I don't know that there was another defendant involved? I'm suing one of the two defendants, but I don't know about the second defendant, that it doesn't relate. That's not a mistake for purposes of Rule 15. What's your best case on that?
Well, I think if you look at Timon, at 214 Arizona 77, and I guess I should get you the full site for Timon.
That's right. We got it. We can look for it.
Timon specifically
Dr.
says.
Howe is very familiar with Timon.
Yes.
If I may read a quote from Timon for you, if you don't mind my doing so.
Sure.
Rule 15C2 requires a mistaken belief at the time of filing that a defendant is appropriately named, as well as subsequent discovery that there was a mistake in identification. Rule 15C2 is not satisfied when the plaintiff simply has no knowledge of the identity of the appropriate defendant when filing the original complaint. I think that's exactly on point to the question you've just asked me.
But we're not saying I'm hit by a car and I don't know who the driver is. We're saying I was hit by a car and I thought I knew who the driver was, but now you're telling me there's someone else who was actually behind the wheel at the time that this happened.
With all due respect, Judge Jones, I don't think that's the case here. We're not saying the guy you sued wasn't in the car. Bellamont and Oldacre were actively involved in the shoveling off or the machining off of the ice and snow on the platform where plaintiff claims to have been injured. It wasn't a mistake to sue Oldacre and Bellamont. They are proper defendants. They are still in the case. And I guarantee you that if you send me back in this case, they are not dismissing Bellamont and Oldacre. I guarantee that. They are appropriate. I think what is, once again, just to use your analogy to follow it through, if the driver that they sued was drunk and they forgot to sue or didn't realize he was drunk and didn't sue me as the bar that served him, but then 2 years later said, hey, wait a second, the defendant said that, you served me the alcohol, so that's a non-party at fault. That's not relation back. And I am more in that category. When I say I am, Applee is more in that category than I had the name of the driver wrong. We have a different obligation, a different position in the case. Now, you can argue about what the obligations of the general contractor are, but when the owner doesn't just contract with the general contractor, but actively takes part in the maintenance of the project, is there every day giving directions, and actually is the party who cleans off the ice and snow on the area where plaintiff claims to have fallen, that is a whole different thing than just saying there was a mistake.
But isn't Timon really a situation where you're just filing placeholders? I mean, you're just naming. I mean, in Timon, I think it was they knew these weren't the proper defendants, And they just said, well, we're going to sue anybody because the statute of limitations is going to run until we find out.
Certainly, Timon is a placeholder case. There's no question about
How do you
that.
get around Flynn, then? What about Flynn?
Honestly, I don't remember Flynn.
Well, maybe it was filed after your briefs. That Flynn was decided.
Probably 4 or 5 months ago.
I'm unfamiliar with it, Your Honor.
Okay, Flynn v. Campbell, 240 Arizona 265. Okay.
I apologize. What can I say to you? I don't know the
Right,
case.
it was after your briefs. I mean, it was after your briefs were filed. That's what you can say.
But I will go back to Timon and say that Timon also says lack of knowledge as to the appropriate defendant, as opposed to mistaken belief that a defendant is liable, does not constitute a Rule 15c2 mistake, and that's at 214.76. And unless that's been overruled, I don't know by Flynn, and I apologize, Your Honor.
Timon's an Arizona Supreme Court decision. Flynn is an Arizona Court of Appeals decision that harmonizes Timon, I think this is fair to say, harmonizes or attempts to harmonize Timon with a U.S. Supreme Court decision interpreting Federal Rule 15C2, or C, Krupski. And if I understand it in Flynn, a mistake can include a misconception or misunderstanding regarding the roles played by prospective defendants.
But if that's the holding, Your Honor, there's no misconception on the part of plaintiff. Mm-hmm. This is not a situation where he misunderstood our role.
Did he understand you had a role?
He understood how to role, right. Right. It's not a misconception of our role.
From your point of view, it boils down to a discovery problem. However, that would play out rather than a Rule 15C problem.
That's what I believe it is. I believe it's a discovery situation. And he has some obligation. I mean, the case law is pretty clear that there has to be some effort made by the plaintiff to discover.
And was this argument made, was this discussed before the trial court on this?
Yeah, I mean, I don't know that it was discussed in the oral argument, which was a long time ago, which in all honesty, I don't remember, what was exactly said in an oral argument a year and a half ago. I apologize, but I don't remember.
But can you remind us, though, what the basis of the trial court's ruling?
Well, I think the trial court's ruling basically was, with regard to the discovery rule, that the plaintiff did not take any steps himself. I think it's really summed up in plaintiff's own deposition. I asked him in deposition, what steps did you take between January 25th, 2012 and April 25th, 2012 to determine whose fault it was that you had been hurt? Answer, none. I mean, so, I don't think it would have been difficult. We cite, that if you, I don't expect the court to read depositions, but if you would read the depositions, you'd see that there were many avenues for him to learn that we were the general contractor on the job. He investigated none of them. And so under, I think, the Gust Rosenfeld case and the Roe versus Doe case, there's really no argument on the discovery rule that it would have been A, difficult to discover it, or that B, plaintiff made reasonable efforts. And I think that's where this case lies, is in the discovery rule as opposed to the relation back. Because I've used a number of examples. I won't just repeat them again.
You've got to prevail on appeal on both of those.
Of course. Of course. I understand I have to prevail on both of those arguments. That if either one of those arguments is in favor of the plaintiff, the case comes back. Of course. Okay. But I think that they have two separate purposes. I think that the discovery rule has the purpose of applying to this kind of case where the plaintiff was unaware of the existence of a different defendant.
For when the statute of limitations starts to run. That's the discovery rule.
Right.
As opposed to relation back, where there was a mistake made, the cognizable mistake made under Rule 15, that you're allowed to amend and it will relate back to the filing of the original complaint. Those are the two concepts we're dealing
Right.
with, right?
And you know, and Your Honor, if what, I mean, it's what you guys do, right? I mean, you make the decision as to how you're going to interpret the law.
That's what we've been told. That's what I think that's what our oath says on the document.
You know, and if you want to make the determination that even though the rule says identity, and if you want to say, you know, in terms of the mistaken identity, and if you want to say, well, you know, if we didn't know of the existence of a separate defendant, not a mistake in who the defendant is, but we didn't know of the existence of a separate defendant who could also have been sued, that's covered by Rule 15, I guess you will. But I don't think that's a fair reading of the rule and the actual language of the rule. And I apologize for not having read Flynn, but I certainly don't think it's a fair reading of Tynan either. You know, the statements of the Supreme Court. Well, clearly the facts of Tynan are different than this because they were, as you said, placeholder defendants.
Placeholder defendants.
Yeah, no question they were placeholder defendants. But I don't think that the court's discussion and holding is necessarily affected by the fact that they were placeholder defendants. I think it's a discussion of what does the rule contain and what is the reasonable interpretation of a rule that specifically makes reference to the identity of the defendant, a mistake in identity. There was no mistake in identity. It wasn't, and I know my time is about up, but it's not that they sued Bellamont, they sued somebody named Bellamont, and they thought, you know, mistakenly because that party was actually somebody named Smith. They sued Bellamont because they thought Bellamont was responsible, and they didn't sue us because they had not made a discovery of it. But my time is up, Your Honor, unless you have further questions.
Thank you.
Thank you, sirs.
Mr. Abney?
That I'm intrigued by counsel's argument. Can you explain why he's wrong?
I'm intrigued too, Your Honor. I think that he's reading too much into Timon, especially if you take into account Flynn and then Krupski itself, which really came down, as far as mistake in Rule 15C, the Krupski court held that the only question is whether the defendant knew or should have known that absent some mistake, the action would have been brought against that defendant.
But given Timon, which doesn't say that, I mean, I understand, and Judge Howe, Dr. Howe and I have had a running, in the Sun Devil tax case, we have a running sort of dialogue that Timon sort of controls because it says, what did the plaintiff know? And Krupski seems to say, no, what did the defendant know? But why isn't Timon, the language that he pointed to in Timon, controlling here?
Well, if you talk about, let's see if I get the Timon language right, not satisfied when the plaintiff simply has no knowledge of the identity of the appropriate defendant when filing the original complaint. The plaintiff had knowledge of the identity of an appropriate defendant and was trying hard to sue all the proper defendants, which he assumed was one, the landowner, owner of the property. And he got that right. And based upon the knowledge, the direct knowledge that he had, he thought, well, there's nobody else. This is the person to sue because who I want to sue, the identity of the person I want to sue, is the person who was in charge of this project as far as safety and my personal safety as somebody working on the project.
So if an accident occurs, you know that at least one person is a proper party to sue.
Correct.
You don't know if there may be others. As long as you sue one proper party, then when you later on discover other proper parties, then that all relates back under Rule 15C?
Well, if you later discover there are proper parties, Rule 15C exists for you. You get the statute of limitations plus 120 days, and if there's been a mistake, then you have the right to correct that mistake.
That seems to be reading a mistake of identity rather broadly.
I interpret the rule rather broadly, and Timon, I believe this court is taking a generous view of how you can interpret it. At least that's what I got out of the Arana decision.
So you end up blurring, I guess, in certain circumstances. You blur a discovery analysis with a Rule 15C analysis, and it seems that they're dealing with two separate kinds of problems.
Well, I don't know if I'm blurring them. The discovery aspect is pretty clear, and it's a separate kind of issue. But if you swing into 15C, if you look at the plain language of the rule and the way courts have recently been interpreting that rule, I think they're reverting back to the plain language of the rule, which is probably where courts should have mainly stayed in the first place.
No, I mean, as Judge Kessler's alluded to, we've dealt with a rule with Rule 15 before, and at least in your opinion, in Sun Devil, we discussed what it means to have a mistake in identity, because in Sun Devil there was an obvious mistake. The plaintiff didn't believe it needed to sue the defendant, that it subsequently learned that it needed to sue. So that was a mistake.
It was a legal mistake.
Yeah.
It was a legal mistake.
Yeah, but if you're starting to get into areas of that, aren't you starting to talk about strategic decisions that a lawyer makes about who you should sue, who you shouldn't sue? And that's not where we are in this case at all. If you go back to Timon, I think that things that aren't protected under Timon, very clearly under its language, are a deliberate decision not to sue a party whose identity plaintiff knew from the outset, or a mistake of law by counsel regarding whom to name the lawsuit. Those two are clearly outside Rule 15C.
That's more Sun Devil. That's more Sun Devil.
So we read mistake of identity to mean mistake of fact. I mean, I think we all agree if there's a legal mistake that falls outside of 15C.
It doesn't matter. For this case, it doesn't matter. Right.
But what you seem to be saying, and I think is a fair reading, that your client made a mistake of fact, that your client wasn't aware that there was an additional proper party.
Correct.
And that mistake of fact is a mistake of identity, and
right.
I'll have to think about it. But that really reads identity rather broadly, in my view.
And I know you want to respond to him, but I just want to sort of follow up on this. What's your best case that says if there are two possible defendants, I only know about one of them, I don't know about the other one, I later learn about that, that's a mistake of fact sufficient for purposes of Rule 15C?
I believe in general it would be. There may be
Best case.
That case?
Best case to support that argument.
Oh, Krupski. I would go with Krupski. Oh, and Arana. I think Arana is a wonderful, and I'll put it into a supplemental citation of legal authority, Arana, Arizona App, September 29, 2016.
Okay.
So
we can look to that for persuasive authority.
It's incredibly persuasive. It's written by one of the greatest appellate courts in the world. So yes.
Okay.
Yes. I'll do what I can here.
And so you're saying Krupski and
Arana.
Arana.
And I think if you take another look at
what about Flynn? Does Flynn help you?
I don't have, well, yeah, although I always thought that the main issue in Glenn was the period of time, but the role played by successive defendants, that makes sense too. But if we return a little bit to Timon, I thought there was a very interesting statement in there. It says, we start from the assumption that by definition, every mistake involves an element of negligence, carelessness, or fault. Absolutely right. And Rule 15C encompasses both mistakes that were easily avoidable and those that were serendipitous. Very well put. And you there's an element here from my colleague across the aisle, well, this is one of those mistakes that was easily avoidable. Well, that falls within 15C. And my last plea, I think, on Rule 15C is it's designed to remedy a situation. It's designed to come to the aid of a plaintiff who has screwed things up. And this is an opportunity.
Well, but it's designed to come to the aid of a plaintiff who screwed things up in a particular way. When you...
Oh yeah, I mean, I'm stuck with the words, but they're actually pretty generous words. Knew or should have known that, but for a mistake concerning the identity of the proper party. And here, unquestionably, there was a mistake about the identity of the proper parties.
But doesn't Mr. Herzog argue that you should have known that there was someone else out there that had to be named?
Yeah, but why should you have known
That's
that?
my question to you.
Well,
Is he's saying, Mr. Oldacre, I believe it is, that he was the owner of the property, and everyone knew he was the owner of the property. No one had reason to suspect he was the general, as I understood the argument. And you should have known that while you served Oldacre in the proper capacity, you failed to go after the next step or the next entity that was involved, which was the general in charge of the work site.
but from Richardson's perspective, he thought he had the person who was in charge of the project.
Because?
Because that's Oldacre was out there doing things that a general contractor would do. There never was an appearance on the site by a general contractor that he saw, and there was no sign indicating a general contractor. Nothing ever came to his notice or attention that there was a general contractor involved.
Oldacre filled two roles, you're saying?
Oh, sure. He owned the land, and he was out there actually he was working, he was directing things that were being done, he was clearing the ice and snow, and of course it was the snow icy condition that got my client.
Well, before we go down that route, should have known goes more to the discovery issue.
Yes,
Whether he
although
should have known, whether Richardson should have known that there might be another possible defendant and could have done something to find out goes to the discovery rule. Whether it's a sufficient mistaken identity that he didn't know there was another proper defendant is a
Right.
question of the
in fact,
rule.
So,
for the jury.
so if the claims made a mistaken identity, then Mr. Oldacre shouldn't be in the case then, right?
No,
because there was a mistake made.
No, I think you could probably still hold Oldacre into the case for maybe negligently choosing a proper contractor, having landowner liability. Now, if you're liable for people who you invite onto your premises, there's all kinds of ways you can keep the landowner in a lawsuit. But that doesn't mean, and so he was a proper party to sue. I don't have any question about that. General contractor is responsible, though, for safety on the work site as well, and can be held liable for that. So you have two viable defendants here. The trouble was Richardson, based upon what he knew, his experience, everything he saw and didn't see, led him to believe that the landowner was the one in charge.
Let me. I've been accused of having a firm grasp on the obvious, but let me make sure if I have that firm grasp. It seems to me the difference between the two parties is a mistake of fact sufficient if there are two proper defendants, and you didn't know about the second. Is that a mistake of fact sufficient for Rule 15? That becomes the issue. Is that a fair statement?
Yes.
Okay.
For Rule 15.
For Rule 15, as opposed to, I thought it was Joe Smith Corporation and it was Joe Flynn Corporation.
And Joe Smith.
And Joe Smith.
Right.
But I mean, okay.
So the rule presents a mistake of fact. It doesn't present a mistake of identity.
It's for correcting a mistake of identity, which can be, of course, a mistake of fact.
Right.
Mr. Happy, you're way over your time.
I know, but you guys, you gentlemen kept asking questions.
When you got done with your first argument and you had more than half your time left, I know you were thinking you were going to get out of here easily and quickly.
Yes, Your Honor, I did.
Not going to happen.
Well, it's a pleasure, gentlemen. Thank you very much.
Thank you. Thank you. Counsel, we have obviously enjoyed the argument. You know as well as we do, we could have gotten this done in a lot less time if we just sat here and listened, but we really did have some concerns about those issues we've raised, and you have addressed them admirably. We're going to take this under advisement at this time. We will issue a decision in due course. We do thank you for your argument today and for your tolerating our curiosities, let's say. So thank
This
you.
was fun.
With that, we are adjourned. Thank you. And we're going to remain here if the next case could come forward.